May it please your Lordship, I am Mr. James Quayle and I appear on behalf of the appellants in this matter, Mr. Croker, Mr. Bridger, Mr. Peach and Mr. Altabani, together with my learned friend Mr. Daniel Green. The respondents on behalf of the Crown are my learned friends Ms. Chloe McKinnon and Mr. Daniel Mutton.
Thank you.
The grounds of appeal for this case are that the judge in the trial dismissed the jury incorrectly and that they should have been allowed to hear the case. The judge ignored Mr. Altabani's plea that he was less liable under non-insane automatism as he was suffering from PTSD. And finally, the sentences given were unduly harsh and not in accordance with sentence guidelines. I would like to come to our first ground of appeal, which is that the jury was dismissed incorrectly by Judge Hangman J. Under the Magna Carta, enshrined in our British legal system, is Clause 39, which states free man shall not be imprisoned unless by a trial of his peers.
Are there some other words, or according to the law?
This is letter of Magna Carta.
Sorry?
This is under the Magna Carta.
Right, okay.
By stripping the trial, by stripping the jury from the trial, Judge Hangman J deprived all four of the defendants of their right to a fair trial, and I deem it was unconstitutional for him to do so. Now, without the impartiality and neutrality of a jury, and without their right given to them under the Bushell's case of 1670, are you familiar with the facts of this case?
Yes, thank you very much, yes.
Okay. Under this case, it was said that their juries have a right to give their verdict by their conscience. And yes. Lord Devlin himself stated in 1956 that juries are the light that shows freedom lives. And in this trial, I deem it was unfair that the four men were left without the protection of the jury's neutrality, and that the judge was more prone to coming down in favour of a prosecution and dismissing Mr. Altabani's plea.
Are you saying that in all cases, there must be a jury trial in all criminal cases?
I believe it's within the rights of those on trial to be tried by a jury.
Because the great majority of criminal cases are tried by magistrates. Are you saying that all the people who are tried by magistrates could insist on a jury trial?
I deem it, since they're lay people and some jurors.
Sorry?
The magistrates are lay people along with jurors. It's similar in a way.
So, just to be a bit more technical, if you have you have lay magistrates, you're absolutely right. So I see how you say that like a jury. It's a good point. But you might say that there are some magistrates who are professional, who sit on their own. You're saying that the effect of your argument would be that a person tried before a magistrate, a stipendiary magistrate, they used to be called now a district judge, could insist on going for a lay bench, a lay magistrate. Do you say that?
I'm not stating that at all. I think more in the case of a Crown Court trial, where more is at stake, I think that it should be more of a right to trial by jury, where more is at stake, and a sentence of quite severe length is at a definite risk.
Right.
Before you go on, what are you saying is the merit of having lay people as opposed to lawyers? Because the example you gave, which of the lay magistrates, also presupposes lay people.
Well, I think that it's more, it makes the system more open. The juries themselves are more impartial, and again, they make the system more open to the public, installing confidence in the legal system. I would like to continue to...
yes, please.
To the Criminal Justice Act of 2003, where it is written that a judge may dismiss a jury for several reasons. Under Sections 44, a judge can only dismiss a jury where there is evidence of a real and present danger, or there is notwithstanding any steps, including police protection, which might reasonably be taken to prevent jury tampering. The likelihood is that tampering was so substantial it would take place. And under Section 46, the judge decides to discharge a jury and is satisfied that tampering has taken place. They have the options of point 3, 4 and 5 available to them, either to continue without a jury, if it would be fair to do so, if it would be in the interest of justice to do so, and if he discharges the jury under Section 46.4, he may make an order that any new trial must be conducted without a jury, and he may fulfill the role of a jury in that trial. However, in the trial at hand, the judge did not take other measures, such as in the case of R. and Comerford 1998. Is your Lordship familiar with this case?
Yes, thank you.
Such as police protection in the case at hand, or simply dismissing the jury and bringing a new one in. Furthermore, there was no concrete evidence in the trial. It was merely an anonymous note. It could be from anyone. And it only stated that several jurors were anxious. It could be two, allowing that the jury would be able to proceed with a majority verdict. And furthermore, anxious doesn't imply that any attempts were made. Maybe they may have been anxious perhaps after the trial, not necessarily during the trial.
So your argument really is, in the first place, it was wrong in principle to continue without a jury or to hear without a jury, and secondly, that even if it wasn't wrong in principle, the arguments weren't strong enough on the facts of the case.
That's true.
We haven't got a great detail of the facts, have we?
Not at the moment, no. We
No.
do not know too much about the validity of that note that was given to the judge.
Yes. I mean, it might be said, can one take into account that on the face of it, these were very serious charges and violent and criminal men, and therefore the judge, it's not surprising that the judge may have been concerned about what the jury said.
Again, there are other measures that he could take. Again, it states that these men were leaders, or he made the presumption they were leaders.
Yes.
However, we do not know that. Again, it can still be put in police protection. It may be expensive, but it's still better than removing a jury who can still give an impartial verdict.
Well, you say that, but if we look at most countries in Europe, they don't have juries, don't seem to feel the need for juries. Is there anything so special about juries, or is it just a sort of English hang-up?
I wouldn't say it's an English hang-up. I'd say it's still quite important that we have that neutrality in the system.
Even though many other countries don't have it?
Even though, yes.
What's special about us, then, that we need it?
I'd say that it offers those defendants it's like the last barrier of defence in a way. With that jury being neutral and impartial, they are the arbiter of fact in the case, and they decide what they believe is the necessary convictions, whereas the judge leaves it down to the letter of the law.
Can I follow that up? So in our civil cases, suppose I got into a car accident and I wanted to sue the other driver. I wouldn't have the benefit of a jury then, but do you think I have a neutral and impartial person to decide my case for me?
I'd say it's a bit different for civil cases. In a criminal case, your freedom is potentially at risk, whereas in civil cases, it still may be financial, but it's less serious when you're free. You still have your freedoms. When a criminal is on trial, or an accused criminal is on trial, their freedoms could potentially be taken away from them by a judge who may be biased towards prosecuting them without a jury.
Or biased towards defending them?
It's true. We do not.
Yes, please.
Thank you. Furthermore, I hold that under Article 6 of the Human Rights Act 1998, the trial by jury it goes against the European Convention of Human Rights. UK courts must interpret the law and follow the Convention rights in order not to be in a breach. And in the precedent followed in this case of the R&T v. others, or R&T and others, 2009, really that precedent is bad. Declaration of incompatibility should have been made in that case. And furthermore, the way the case was conducted wasn't very good. The judge encouraged witnesses and barristers to skip through evidence and rush through pieces that may have been very important to the trial, and I hold that it was bad precedent to follow.
Now, RVT, as it's now known, R&T, actually went to the European Court of Rights in Strasbourg and applied for permission, and Strasbourg said it wasn't admissible. So doesn't that suggest that, in fact, there wasn't any sort of Article 6 issues raised in R&T, the one you just relied upon?
Well, it's a similar offence that's been committed here. It's difficult to say. Depends on what the members of the European Convention of Human Rights, or the European Court of Human Rights, believed in at the time. But when it keeps recurring in a justice system that has the jury, I think maybe the Criminal Justice Act of 2003 might be needing review concerning this. A case where the Article 6 was raised and it was, or the case judgment was changed, was Othman Abu Qatada in United Kingdom 2012. Are you familiar with this case, Your Lordship?
Thank you.
Yes. Where a case decision in RB Algeria and other appellants and
Yes.
Secretary of State for the Home Department 2009 was overruled. So it so Article 6 can be changed by the European Court of Human Rights. Again, it depends who really reviews the case, and it depends the seriousness of the case and its own merits. But when, again, a case like this keeps happening without a jury, I deem it that it should be reviewed. Abiel, thank you.
Thank you very much indeed. Thank you.
If it pleases your lordship, I'll now introduce the second ground of appeal. Hangman J, the judge in the case, was wrong to dismiss the defence of non-insane automatism. Firstly, I'd like to draw attention to the Law Commission report, a scoping paper on insanity and automatism. This is relevant as the current law regarding automatism was outlined. It stated the following: the defence, or automatism, also applies to acts done while suffering concussion, under hypnosis, or while under the effects of anaesthetic, as well as in cases of diabetics who suffer from a blood sugar crash, hypoglycemia, and people acting while suffering from post-traumatic stress disorder. This highlights that post-traumatic stress disorder is recognised as a valid offence by those legal experts in the Law Commission. Secondly, I'd like to raise the case of R&T. Is your lordship familiar with this case?
Yes, thank you.
In this case, Lord Denning stated that any mental disorder which has manifested itself in violence and is prone to recur is a disease of the mind. This, by legal definition, would constitute insanity, not automatism. However, in the case of R&T, rape was the cause of post-traumatic stress disorder. Now, the legal definition of rape is the unlawful sexual intercourse or any other sexual penetration of the vagina, anus, or mouth of another person with or without force. This shows the act of rape caused the post-traumatic stress disorder through violence and is likely to recur. However, it was still accepted as non-insane automatism. This should be applied to the case at hand, as the post-traumatic stress disorder Altabani suffers was from the cause of violence experienced in combat serving in the army and is likely to recur. By taking the decision made by R&T, the judge Hangman J should have allowed the defence of non-insane automatism.
Sorry, could you express in your own words what you understand by the word automatism?
An involuntary act caused by either hypnosis or concussion, something that leaves the muscles to act on their own will, like a spasm.
And you know the facts, you mentioned the facts of R&T
Yes.
from 1990. Do you know what the crime that the lady in that case committed was?
Yes, she committed robbery and ABH.
Yes, she committed a robbery at knife point. I mean, does that seem like something someone does sort of automatically, like a robot or an automaton?
There are a lot of cases where people have done such things, such as in the case of Roach 2001, a man stabbed a co-worker in the hand after a small disagreement. This was left as non-insane automatism when the appeal was held, that the jury should have decided it. So you can see that some people can do this in such states. I would now like to move on to the second point, that the expert diagnosis shows that the defendant was in a state of post-traumatic stress disorder and non-insane automatism. Is your lordship familiar with the case of Hill and Baxter?
Yes, thank you.
Lord Justice Devlin said in this case, "I do not doubt that there are genuine cases of automatism, but I do not see how the layman can safely attempt, without the help of some medical or scientific evidence, to distinguish the genuine from the fraudulent. The medical evidence provided in Altabani's case shows that the genuine was proven and the fraudulent was not. Furthermore, I submit to your lordship that the act done was involuntary. Is your lordship familiar with the case of Bratty v AG Northern Ireland?
Yes, Bratty, yes, I am. Thank you.
This case established that no act is punishable if it is done involuntarily or an involuntary act, or an act done by a person who is not conscious of what he is doing. In addition to this, as I was mentioned in Roach 2001, the Court of Appeal stated if external factors are operative upon an underlying condition which would not otherwise produce a state of automatism, then a defence of non-insane automatism should be left to the jury. Now, although the judge took on the role of the jury, he was very biased, you could say, in doing so, as he was too quick to throw out the defence of non-insane automatism.
Do you suggest he read the expert's report?
I suggest he did, but in some cases it needs more than just that. Psychiatrists should be used instead of just throwing it away as if it was nothing.
But if he read the report and thought to himself, well, even if this evidence stands up and isn't undermined, I don't accept that this is automatism, was he not entitled to do that rather than waste time listening to the cross-examination when, even if the witness had supported everything he'd said, the judge wouldn't have accepted it was automatism?
He's perfectly entitled to accept that, but you cannot diminish the cases that have been provided in the past of R&T that show that medical evidence is enough to support post-traumatic stress disorder.
But he had the medical evidence, but unlike those cases, he was trying this on his own. So it wasn't a case of letting it go to the jury. One could say, well, it was going to be his decision. He read the expert's report. He decided, even if everything here is true, I don't accept it was automatism. Could that be an analysis of what he did? And if he did, was he not entitled to do that?
It is analysis of what he did, and he is perfectly entitled to do so. But when you have such overwhelming evidence, if the case be, then it should be accepted and at least be sent to a jury if they're not improperly dismissed.
But if he hasn't got a jury?
He shouldn't have dismissed them in the first place, as we have seen in the first ground of appeal.
Yes, I see. But if you win on the first ground of appeal, you don't need this ground. If you lose on the first ground of appeal, then we are assuming that he's all right with the judge. So could he not have said, I don't accept this?
As I've said, he's perfectly within his right to do so. But I feel like such a high-profile case, being that it was a gang, the evidence should have been taken in every merit. And it shows potential bias of the judge, as he may be prosecution biased.
Yes, I see. Thank you.
I'd also like to direct your attention to the first handout, if you have it, the one labelled Automatism.
Yes.
As we can see from the highlighted route, if you have it.
I'm not sure I've got this. Oh, sorry. Thank you. Yes.
As we see, the total loss of self-control is automatism.
Yes.
And if you follow down the yes path, as there was, specific intent to crime, that's a no. Following it down, did D recklessly cause their own automatism? No. This shows that it was automatism, if you follow this correctly.
Yes, I see.
And if it pleases your lordship, I would now like to move on to the third ground of appeal.
Thank you. The sentence.
Yes. First of all, I'd like to highlight the location of the robbery. Now, this was in a warehouse, not a bank, making it a less sophisticated commercial robbery. There were no armed guards or security at the premises, otherwise the men armed with basebats would not have gotten far. The presence of said authorities would deter...
Why does that make it less serious?
As the presence of guards and authorities would deter less professional guards. So if it was at a bank and there was an armed guard, then they would not have even tried to rob the place, as they would not be well equipped.
So they should be credited for picking on a vulnerable.
I'm not saying that at all. I'm saying they chose a place that would suggest it was a less sophisticated commercial robbery with what they had.
Thank you.
And if you could look at the handout of sentencing guidelines now.
Yes.
We can see that for adult offenders, if a weapon is produced and used to threaten, which it was, then the sentencing range is 2 to 7 years and not going on a minimum of 15, as was given. If you look at additional mitigating factors at the bottom, a peripheral involvement was seen in Altabani's case, as he was merely a getaway driver. And the judge and jury should accept that if post-traumatic stress disorder is not seen, then 2 years minimum should be given for this peripheral involvement.
Now, you've given us part of the sentencing guideline
Yes.
here, but isn't another part of the guideline which talks about something you've already alluded to, which is sophisticated commercial robberies?
Yes.
And it says in those cases, 15 years would be an appropriate starting point.
But as I've stated before, the location suggests that it was less sophisticated, as the use of baseball bats and batons shows that they weren't exactly well prepared for a professional robbery in a bank.
They did plan to have a getaway driver, though. It would suggest some kind of level of planning in advance, doesn't it?
It does show some level of planning, which can be seen as an aggravating factor, that they planned this and that wasn't a spur-of-the-moment crime, which, if you let me get on to the sentence for Croker, Bridge and Peach, shows that additional aggravating factor that they planned this shows that it could be a maximum of 7 years if you take that it was less sophisticated commercial robbery. In addition to this, if we're looking at mitigating factors, they showed somewhat cooperation, as they did not hold out until police entered the building, which may have caused injury to the police if the robbers fought back.
The police were there in very large numbers, weren't they?
They were indeed.
It looks as if it would have been hopeless to try and...
Yes, it may have been hopeless, but what you must remember is that they had hostages in the building. They had some of the workers there tied. So they could have used those to bargain their way out, gain some sort of leverage with the police, but they did not. They gave up and they came out on their own merit.
Yes, I see.
After 3 hours.
Pardon?
After 3 hours.
After 3 hours. but they did not harm the victims that were tied down while they were there.
I think the people who were tied down might view that itself as being harmful.
They may, yes, with the detaining of the rope, but they weren't beaten or used to show like a message to the police in any way.
More like saying there was no aggravation rather than there was mitigation, isn't it?
And apart from the 3 hours, there was no lasting damage to the victims as they were merely tied down. There was no humiliation to them.
No, I understand.
And also, as my learned friend mentioned in the first ground appeal, Hangman Jay described Croker, Bridge and Peach as the leaders of the gang. This was an error in conducting his duties as a jury, which he undertook by dismissing them, as the jury are the arbiter of fact. However, he mistook the three men as he described them as the leaders, whereas this was a mere presumption and resulted in them getting a harsher sentence when this should not be implied. So as for the three leaders, we can see that a maximum of 7 years for the aggravating factors in ties, with half the sentence they were given, showing a more just sentence.
Yes. Thank you.
Thank you.
Thank you very much indeed.
Thank you, Your Lordship. As this is a high-profile case, great care would have been taken, for example, with the measure of police protection, to prevent jury tampering. However, it has happened, and we can see from the fact that 5 of the jurors, which is nearly half of the entire jury, suspected there were anxious feelings amongst the group. This means that the likelihood of some form of intimidation taking place, and therefore jury tampering, is substantial. Again, the nature of the case leads my learned friend and I to believe that the vetting of the jury would only lead to further jury tampering, which would, of course, disrupt the trial procedure and pervert the course of justice. Moreover, the cost of protecting any jury would surely be a heavy burden upon the courts. Therefore, as the guidelines state, it is within the interests of justice for the trial to be conducted without a jury. It would be unfair on the multitude of victims in the case at hand to allow a trial by jury to go ahead despite the clear evidence that it has been contaminated.
You say clear evidence that it's being contaminated.
Yes.
Is there really clear evidence if some members of the jury think that other members are keen to acquit? Is that enough?
I believe that the fact that the jurors would go to the length of informing the judge that there were anxious feelings amongst the group, or that they suspected so, that obviously there is evidence that something has been going on, and I believe that is sufficient evidence of jury tampering.
Thank you.
Furthermore, Clause 39 of the Magna Carta is, when it comes down to it, purely persuasive precedent in court. Of course, it has a huge historical significance, but my learned friend and I believe that it would be disrespectful to the pioneers of the English justice system if your lordship discretion was not used in this case. In other words, while the Magna Carta is an integral part of the law, we must also recognise that sometimes taking the unconventional approach can also be part of the law. But this does not mean that Hangman Jay's decision to conduct a trial without jury was arbitrary or anything of the sort. If we look to the case of R&T, R&B, R&C, R&H, 2009,
Yes.
then we see this is not the first time a trial without jury has taken place. Is your lordship familiar with the facts of this case?
Yes, it was rather clearer evidence, wasn't it? Wasn't there in that case that there had been jury tampering?
In the case of R&T?
Yes. Well, in some of those cases, anyway.
I'm not exactly sure about the evidence of jury tampering within that case, but if we look at the facts of the case, and we see an armed robbery against a warehouse at Heathrow Airport had taken place as well.
Yes.
And the actual appeal was against a decision of Calvert Smith J, who refused for the jury to be conducted without the concerns, refused for the trial to be conducted without a jury, despite the concerns of jury tampering. Whereas in the case at hand, Hangman Jay has decided that he was capable of doing such a thing. And we are all acknowledging that trial by jury is a right that belongs to us all. However, when this is tampered with, we are left with a difficult situation. Lord Bingham defined jury tampering as if the integrity of an individual juror, and therefore the jury as a whole, is compromised. Such a compromise occurs when any juror, whether because of intimidation, bribery, or any other reasons, dishonours or becomes liable to dishonour his or her oath as a juror,
Yes.
by allowing anything to undermine or qualify the juror's duty to give a true verdict according to the evidence. And this was seen in the case of R.V. Comerford, as my learned friends have mentioned. Now, the case of RVT states that the legislation is unequivocal and unambiguous. The judge is required to make the order when the conditions in section 44.4 and 44.5 are fulfilled, which in this case they are, and therefore Hangman J was following the law correctly.
Sorry, going a step before that to subsection 3, what exactly does the judge need to be satisfied of before he starts making this kind of decision?
Do you mind if I just consult with
Of
my
course,
learned
please
friend
do.
for a second?
44.3.
That's the one, yes.
We believe that the Criminal Justice Act 2003 states that if there is sufficient evidence of jury tampering, then the judge is allowed to conduct the trial without the jury.
So it says if he is satisfied that jury tampering has taken place, but what's the threshold for that? If, for example, he was sitting on the bench and he thought that juror number 9 looked particularly scared, would that be enough?
May I consult with my learned friend again?
Please do.
Sorry about that, Your Lordship. There would have to be some kind of physical evidence, not just for the judge to look at the juror and think, they maybe look a bit anxious. It would have to be, as we see in the case at hand, some form of note or a comment made by someone.
Thank you very much. Yeah, that answers my question.
In this case, it was decided that the most appropriate standard of proof would be the criminal standard, which is that it is proved beyond reasonable doubts. In the case at hand, surely the jurors would feel anxious for no other reason than they had been intimidated, bribed, or threatened. Therefore, my learned friend and I agree with Hangman J on the decision that this is sufficient evidence of jury tampering.
If the jurymen and women who were nervous because they thought that these were serious criminals who might tamper with them by threatening them, but they haven't done so, isn't that a possibility? And would that be enough for jury tampering, the fact that the jurors fear they might be tampered with?
Is that purely on the fact that the defendants were a gang,
Yes.
like a notorious gang? No, I don't think that would be sufficient evidence.
But might that not have been the facts of this case, that the jurors who got in touch with the judge noticed that the other jurors were favouring the defence and were a bit fearful, but the fearfulness may have been because they were frightened the defendants might do something, not that they had done something.
Yes, I believe that is possible, especially with the use of media today. But as I stated at the beginning, every measure of care would have been taken to ensure that jury tampering did not happen. And because of the nature of the case, the media and the press would have been hindered from accessing the case and revealing the information that defendants were a notorious London gang. Therefore, I believe it is suitable for us to believe that there is real evidence of jury tampering taking place in this case.
Yes, I see. Thank you.
In RVT, a trial by jury was allowed to go ahead and there were no further problems. May I remind your Lordship that this appeal took place in the Supreme Court. While the ability to use a practice statement and overrule the decision in RVT is present, I advise your Lordship not to. The two cases are sufficiently similar in facts, particularly the nature of the robbery. However, the case at hand sees a robbery of a significantly higher value take place, and therefore there is an even higher need to ensure justice is achieved in the most appropriate way, specifically by upholding the decision of Hangman J to allow a trial without jury to go ahead. Thank you.
On that last point, isn't it more important to look at the nature of the risk or threat of jury tampering than to look at the amount of money involved or the seriousness of the crime?
Could you please elaborate, your Lordship?
Well, we're considering here whether Hangman J was right to discharge the jury and go on his own. The reason he did that was because of the risk of the jury being tampered with. You've said in RVT that the crime was similar but less serious. But is that really particularly significant? Isn't it more important to look at what the nature of the risk and what the evidence of the risk of tampering in that case was compared with the evidence and risk of tampering here?
Yes, I believe that on the one hand, if we look at the risk of the jury tampering, the fact that the defendants are a notorious London gang makes that a significant threat, and it is obviously important, to apprehend anything like this from happening again. However, on the other hand, the robbery was of such high value that so many people have been affected by this. And I believe that is also as important as the jury tampering.
Thank you.
Okay, thank you, Your Lordship.
Thank you.
Thank you, Your Lordship. As my learned friend here has already established, the judge was acting as the jury for this trial, and under Section 46 and Section 48 of the Criminal Justice Act, Section 46 stating he's allowed to discharge the jury, and Section 48 allows the judge to take the role of the jury if they're discharged. So we can assume that Justice Hangman is perfectly entitled to make the decisions that any jury would have been making in this case. And the most important decision for the second point of appeal is whether Mr. Altabani's post-traumatic stress disorder made him eligible for the defence of non-insane automatism. And in the case of R.V. Quick, it was established that the decision is to be made by a jury. And so therefore, in that case, Justice Hangman is perfectly entitled to make the decision as he is acting on behalf of a jury. In this case, it's stated that Justice Hangman threw out the defence of non-insane automatism due to the weak argument based on the evidence. Mr. Altabani has 4 pieces of evidence in his statement about his autonomy of his crime.
Yes.
Firstly, stating that he just returned from the army, obviously causing his post-traumatic stress disorder. However, that in no way really proves indefinitely that he did have post-traumatic stress disorder, and statistics show that actually only 12% of British soldiers return with PTSD, and while it's probably reasonable to assume he might have it, it goes no way to showing that he is in a mentally unstable frame of mind.
But, I mean, I'm sure you're going to come on to this, but we're told that doctors, plural, had diagnosed him with post-traumatic stress disorder, and there wasn't any evidence that he didn't have post-traumatic stress disorder, so that suggests that on the evidence before the judge when he was making a decision, he did have post-traumatic stress disorder, doesn't it?
Yeah. So going on to that point of appeal, he states he was diagnosed with PTSD as a doctor's diagnosis. And the case of R&T, which was mentioned earlier by the appellants, the defendant in that case did have PTSD as well, and they were allowed to use that as their defence for non-insane automatism. However, what the appellants neglected to say about that case was that in fact, the jury still convicted the defendant in that, and they rejected the proposal for non-insane automatism. So perhaps Justice Hangman was using that as persuasive precedent because maybe he was using it to think in the mind of a jury, as he'd already seen a jury go against not agreeing with post-traumatic stress disorder, so maybe he was doing the same. And in the case of Narborough, is your Lordship familiar with the case of Narborough?
Yes, thank you.
Justice Zucker's denied the evidence of PTSD for the defence of non-insane automatism, as he said, it failed to refer to any research supporting the conclusion that it can affect a person's normal mental process so he behaves as an automaton. So perhaps Justice Hangman also considered that, is that whilst he mentions he has post-traumatic stress disorder, he doesn't actually show too much evidence as to how it would have affected him, like solid evidence. He simply states it. Which is the point I'd just like to come on to, that he himself states that he had vague memories of agreeing to and taking part in the robbery. However, this evidence can be seen as invalid because we can't just take his word for it.
Isn't the very problem here that we don't have any evidence about the automatism because the judge didn't let it in? So you could your opponents might argue that the information should have gone in front, he should have had all the evidence, he should have heard cross-examination, he should have seen expert evidence, and then he would be in a position to decide whether or not non-insane automatism would be a good defence. But the problem, they would say, is that didn't happen, he just didn't even consider it.
Yeah, I think the reason he didn't consider it is looking at the past cases of R&T and Narborough. He'd already seen 2 examples of post-traumatic stress disorder being denied as a defence for non-insane automatism, so was perhaps just following that to continue on with the case.
Not entirely clear what the judge did. He threw out the defence, but it does refer to him having received evidence, but it doesn't tell us exactly what the evidence is.
In this case?
Yes.
I think it was just a diagnosis from the doctor of post-traumatic stress disorder.
Yes. The defendants were all represented at trial, I take it, by counsel.
I'm not sure. I didn't really say in the facts.
No, it doesn't say.
But I'd assume so, yeah.
Yeah.
Yeah. Finally, we submit that Justice Hangman considered the possibility of the voluntary nature of post-traumatic stress disorder, and in fact, in the case of Attorney General reference number 2 of 1992, Lord Taylor said that the defence of automatism requires that there was a total destruction of voluntary control on the defendant's part. Impaired, reduced or partial control is not enough. And as we can see in this case, Mr. Altabani, whilst he says he only has vague memories of agreeing, he still says that he did in fact agree, showing he must have had some form of control as he's making decisions. And the fact that he was also the getaway driver suggests that he must have been in control of his body in some way, otherwise he wouldn't have been able to drive to and from the crime scene. So I think to suggest that he was completely not in control of his body at all is quite absurd. And also the appellants mentioned about the Law Commission's report on automatism, but the Law Commission states at the very start that they're convinced that there are significant problems with the law on insanity and automatism, and one of the earliest examples we have is only from 1973. So maybe we can assume that this is fairly new law. It still has need for maybe some reform, so that maybe if Justice Hangman did make a mistake in this, it might just be due to the new nature of the law. Yeah. Thank you, Your Lordship.
Very much.
Thank you, Your Lordship. If it may please Your Lordship, please allow me to explain the reasoning behind the sentencing in the case at hand. The robbery that took place is classed as a professionally planned commercial robbery and was committed by a notorious London gang. I'm aware that my learned friends, the appellants, and Your Lordship discussed the possibility earlier of it being classed as a less sophisticated robbery. However, this is at the upper end of the sentencing range, just below the top level, and for this I would like to refer to the case of R.V. Turner 1975. Is Your Lordship familiar with the facts of the case?
Yes, thank you.
Okay, so the judge decided that the sentence should be considered in the context of those imposed with those for murder. It also decided that the starting point for a single armed robbery with no serious injury was 15 years imprisonment, and for the maximum where more than one robbery took place is 18 years imprisonment. I would also like to emphasise that an armed robbery is not limited to firearms, but may also include other types of weapons, and I'll expand on this point shortly. What makes the case at hand so strikingly serious is the extent of the aggravating factors involved. There is clear evidence of the defendants having a high level of culpability. Firstly, the offence was committed by not one offender, but by a group of offenders, who went to the effort of planning the robbery before it took place, which is evidence of professional offending. This and the use of multiple weapons, including batons, rope and baseball bats, to frighten and injure the victims, was seen as sufficient evidence of intention to commit more harm than what actually resulted from the offence. This did not, however, hinder the fact that there was evidence of a more than usually serious degree of harm involved. This was seen in the multiple victims, the especially serious psychological effect on those victims, and the sustained assault on the same victims while they were additionally degraded due to the nature of the assault, which was that they were tied up and gagged.
I mean, obviously it's horrible, but if you have this sort of offence, it's almost bound to happen that people are, that's how they're treated, isn't it? It doesn't alter the seriousness, but it emphasises, what I'm trying to say is that it doesn't make it a special case. Once you've got this sort of robbery, you're going to tie people up and gag them, otherwise you're going to be given away, and does it make it, is it therefore an aggravating feature?
I believe it should be. If we look at the case from the point of view of the victims and the need for retribution and justice for the victims, and you will see for them it wouldn't be justified if the armed robbers got away with a lesser sentence, despite the fact that they've not only stolen, I believe it's £3 million worth of cash and gems, but they had also got away with the fact that they had assaulted the victims while they were doing the crime.
What's special about 15 years? Why would the victims be satisfied with 15 but not with 10?
I believe if you were a victim in that situation, you were tied up, gagged, possibly injured, then I believe you would want the highest sentence as possible. And if we go by
I can understand that, but
Yes.
what's magic about 15? Why not 100? Why not? And if you accept it plucked out of the air, then where does this get you?
I'm not sure, Your Lordship. I think that the sentencing guidelines are set for a reason.
Yeah, that I accept. The
yeah.
sentencing guidelines are a fair point of reference.
Since you bring up the sentencing guidelines, your opponents are saying this is a less sophisticated commercial robbery. You're saying it is a professionally planned commercial robbery. Now, that seems like quite a subtle distinction, but the difference is 7 years in prison, because the guideline for less sophisticated is 7 years and the guideline for more sophisticated is 15 years. I would find it helpful if you could list the factors which you say makes it a professional rather than a less sophisticated commercial robbery.
Okay. So as I stated just earlier on in my point of appeal, the robbery had been planned beforehand. And also they had brought weapons with them, which was evidence that they wanted to commit more serious harm.
There can't be many robberies which aren't planned beforehand, can there? I suppose people might suddenly think it was a good idea to rob a building, but most robberies must be.
I believe so, but if you look at the less sophisticated robbery, I believe on the sentencing guidelines it also says that could be classed as a street robbery.
I see.
Which is on the same level, which would imply it's committed on impulse, possibly.
Yes, I see your point, thank you.
So the fact that there was multiple victims, the sustained psychological effect on those victims, and the assault, and the fact that the offence took place in an isolated warehouse, which only furthers the vulnerability of those victims, leads us to believe that there was a more than usually serious degree of harm involved. And lastly, as I've mentioned, the high value of the property would not only affect the victims, the staff in the warehouse at the time, but also those who actually own the property. The only mitigating factor really to be found is that Altabani did not play such a major role in the robbery, as he was the getaway driver and there is no evidence to suggest that he assaulted the victims. As my learned friend stated, his PTSD may also be considered a mitigating factor. However, he was involved in the planning and execution of the crime. This is not just a crime committed on impulse, but rather a premeditated high-priced robbery by 4 men with clear criminal dispositions, for which the punishment should also be of a high price, specifically in the form of a lengthy custodial term. Therefore, Hangman J was justified and correct in law in his sentencing of the defendants Croker, Bridger and Peach to a minimum of 15 years imprisonment, and Altabani to a minimum of 8 years imprisonment. Just as the defendants have the right to a fair trial, the judge has the right to his discretion. To reiterate, often we must be cautious and sometimes unconventional in our approach to the law, to reflect the times and society in which we live at the least, and to find justice at the most. Thank you, Your Lordship.
Thank you. Thank you very much. Do we have replies or not?
Yes, they've got a right to.
You have a right to reply, I think.
I'd love to.
Good, well then you better take it up.
But try and limit yourself to arguments that they made, so you're responding to their arguments.
The first point I would like to raise is that I've lost it now. Yes, there needed to be more evidence of tampering. There was merely a note. If it was tampering, the note would have been clearer as to say what had taken place. However, it merely said that some of the jurors were anxious.
Well, it may be that the jurors who'd been tampered with were so frightened they didn't want to come up with what had happened, and the judge had to draw inferences from the fact that they hadn't come, and that could be said to reinforce the view that there was tampering.
The fact that the jurors passed a note in the first place shows that they couldn't have been that afraid, and if they were going to pass a note, why not give the full facts? In addition, it's to the judge, and they pass it through the chairman, so they know that it's safe in passing it through, and it's not going to be tampered with.
Yes, I see.
In addition to this, Section 44.3, I believe, was mentioned. There must have taken place, this cannot be any presumptions as to the jury tampering. And mere feelings, this is not to be taken as emotion, fear, cannot be really said to amount to tampering.
Yep.
In addition to this, they said they were anxious. It didn't quite say what they were anxious about. They may have been anxious about beating the traffic getting home. the note would have been clearer, as I've said.
It says anxious about reaching a verdict against the defendants.
Yes.
Well, that's not the same as anxious about the traffic getting home, is it?
No, but if you look at it, they were anxious about reaching a verdict. They may feel like they, as lay people, were not well guided by the judge, or did not know enough about the case, or did not have the facts presented to them in a sufficient manner to reach a verdict, not that they were tampered with and were afraid about reaching said verdict.
Thank you.
Now I'd like to move on to the second point of appeal. The Law Commission are experts in law, and they research law and provide reports for reforms in law, and yet no reforms have taken place so far regarding the law around insanity and automatism. As my learned friend stated, if they did not like the law regarding it, they would publish a report to Parliament.
Yeah.
And also suggested that the judge was acting as an arbiter of fact, and that in cases the judge should have, or the jury should be allowed to decide whether it's post-traumatic stress disorder and non-insane automatism. However, could that be saying that they want the jury as lay people, impartial to the law, to decide, and not someone acting as the arbiter of fact?
Yeah.
And each case must be taken in its own merit. You cannot apply everything from one case. And also vague memories of what had happened. This is not recollection. This does not state that he was not in full control. It merely states that he recognised what happened in past events, not that he had any control over them. And on the third point of appeal, I'd like to raise the point that baseball bats were used. This does not suggest that they were professionally planned. This just suggests they were not stupid and not professional. When you look at robberies of small businesses, there is still a getaway driver. This does not suggest professionality. This suggests they are not stupid. They know they're going to need to get away. They know that some form of force is going to be needed, hence the rope, hence the gagging, hence the baseball bats.
Yes,
this shows there could be still less sophisticated commercial robbery, as they went to the warehouse and they were not stupid in what they were doing. And this suggests, like, from the crudeness of the equipment, they would, if they were a high-profile gang,
right,
which they are, they would come more prepared for a robbery. And also stated by my learned friend was that they were possibly injured. There is nothing in the facts that states they were. None of the no medical reports show they were injured.
I think it was more concerned with trauma than physical
trauma.
Injury.
Yes,
they were obviously uncomfortable.
It can be seen that they had some trauma from the the gagging and the tying up, but there was no application of force. There was no battery of the victims.
Yes.
And I'd just like to make my final point that what robberies aren't planned. You do not just walk by a shop and think that you want to rob that. You have a plan. You go in there with a plan.
But you accept that there's a distinction between, for example, ram raiding, where someone drives a car into the front of a shop and then just grabs whatever they can, and on the other hand, having a planned heist with a getaway driver.
I do appreciate the difference. However, when you look at it, they are similar. There is some use of force. There is a place, it could be less sophisticated, or a high-profile bank. There is still the impulse and the taking of their items that aren't theirs, and it shows that the significant differences are not as much as the similarities, in that there is some level of planning. That's all, Your Lordship.
Thank you very much.
Thank you very much indeed. Well, we're very grateful for the argument. Thank you very much indeed. We will retire briefly and consider our decision and come back in about 5 minutes. Thank you very much. One's many misfortunes of getting older is that you get more prone to allergies, and I think I've developed some hay fever, I'm sorry. But that's not what you come here to hear me talk about. In this case, on this appeal, there are 3 issues. The first is whether the judge was entitled to discharge the jury and hear the case on his own, a case involving 4 defendants who were charged with a fairly serious robbery. So far as the first point is concerned, then, was the judge entitled to discharge the jury and try the case on his own? On the facts as we understand them, we think that this appeal has to be allowed. The judge was told that by some of the jurors that others of the jurors were anxious about reaching a verdict against the defendants. It may well be, I accept, of course, that that was due to jury tampering. But the judge couldn't fairly, in our view, have decided that there had been jury tampering simply on that basis. If he thought, and he could well have thought, that there might well be jury tampering, then the correct course would have been to investigate the matter with the individual jurors concerned, in the presence of counsel for the prosecution and counsel for the defendants. And it may well be that he would have satisfied himself that there had been jury tampering, but then he would have had to go on to ask himself, as the appellants argue, whether in fact jury tampering could be dealt with by protecting the jurors during the course of the trial. So it may well be that Mr. Justice Hangman's decision was right, but we don't think that he approached it rightly by looking at matters as fully as he should have done. Depriving defendants of a right to trial by jury when prima facie they're entitled to such a right is, I accept, a serious matter. However, I think that the appellants put their case significantly too high by relying on Magna Carta. First of all, Magna Carta didn't give a right to trial by jury, gave a right to trial by peers or according to the law, but the words are or according to the law. And in this case, the law specifically provides for the possibility of no trial by jury. As I say, on these facts, it wasn't satisfied. In theory, I suppose that makes the other 2 grounds of appeal moot, because the 2 issues fall away because we have to send the matter back for retrial. But on the second issue, we think Mr. Justice Hangman was fully entitled to reject the case based upon automatism. He was the jury as well as the judge, as it were, on the fact that because of the fact that he discharged the jury and had the case alone. If, contrary to our conclusion, he'd been entitled to do that, then he was entitled, indeed bound, to form a view on the defence of automatism on the evidence. And he heard the evidence and rejected it. We have to say that we don't find it surprising that he rejected it. Automatism is a very unusual requires a very unusual state of affairs where somebody literally doesn't know what they're doing, and or it's completely beyond their control what they're doing. And while post-traumatic stress disorder is a serious condition and could, in exceptional cases, lead to automatism, as the cases show, it would require a very exceptional case, and it's not surprising to us that the judge rejected the argument and the defence in this case. On the third ground of sentence, there's a slight difference between the tribunal. One of us believes that, if anything, the sentences were a bit low. One of us thinks the sentences were a bit high. But I think each of us think that although we might not have imposed the precise sentence that the judge imposed, the sentences of 15 years on Croker, Bridger and Peach, and the sentence of 8 years on Altabani were sentences which were within the range of appropriate sentences on the facts of this case. And therefore, had they been properly convicted on the basis of the judge-alone trial, we would have upheld the sentences. We think the respondents are right. The judge was entitled to take the view that he did of this case and its seriousness and where it fell in relation to the guidance given in the sentencing guidelines. So we allow the appeal on the first point, and we would have dismissed the appeal on the second and third points. Right, that's that. And I'm all bored by that because you want to know who won the moot, really. I think, let me begin by saying that in my career as a student or mooter, I never entered a moot as young as any of you. and I never won a moot in my life. So if you win or lose, it's not necessarily a guide to your future. But I think Hugh here, my judicial assistant, and I, from our different ends of our legal careers, thought that all four of you did very well indeed for people who are still at school in what must be a slightly awe-inspiring location. I find it hard to think of it awe-inspiring because I work here not every day but most days, but it's all the difference in the world between what you're used to and what you're not used to. But it must have been quite awe-inspiring to come here and have to speak, and you probably self-consciously heard your voice echoing around the room as you spoke. It must be quite difficult, and we thought you handled yourselves with great self-possession, and that you dealt with our questions. Some of your answers were not right and were not brilliant, but then I have to say that sometimes very experienced barristers of 50 or 60 don't always give the right answers to questions. So that is not necessarily a criticism. But you all handle yourselves well, and particularly, if I may say so without sounding patronising, bearing in mind the fact that you're still at school, and almost all the moots I've heard have been from people who are either quite a few years through into university or past university and law in doing their law courses. I think that we both thought you did remarkably well, and you're a credit to Strode College. If we have to choose a winner, I think we would, and it's always rather invidious, I think we felt on balance that Daniel Green was the winner. If I have the name right, that's you, yes. He had the two advantages, I think. One was not going first, and the other was having two bites of the cherry. So it may be that subconsciously influenced us. But what I have found when judging moots with other people is that it is quite difficult sometimes to get agreement, because advocacy is very much a question of personal style. If you're interested in pursuing a career as a barrister or as an advocate in court, don't listen too much to what you're told about what's the right and wrong thing to do. It's got to be a personal style. If you are naturally aggressive and noisy, then trying to be silent and quietly persuasive is not necessarily the right thing for you. If you're naturally charming but not aggressive, then don't try and be aggressive. In other words, play to your strengths. It's an individual style that's important. Having said that, obviously having good arguments, well marshalled, listening to the court, answering the questions, not being shy of saying I'd like to check, as you did on a couple of occasions, is all good. And there are obviously some rules which are important and you should bear in mind. But I think it's a question of mixing your own individual style, finding what you're comfortable with and what suits your character, with some basic sensible rules like be clear, answer the question, don't interrupt the judge, and so on. So that's all I wanted to say, I think. I don't know, Hugh, or whether there's anything you wanted to add.
No, in terms of all the points made about advocacy absolutely hold true, and I think there are as many different successful advocacy styles as there are successful advocates. It's just about, as Lord Neuberger said, finding something that works for you. And certainly when I've been working here this year, we've seen a huge number of different advocates from all over the world come here, and there's been so many different styles, and we sort of come away many days and say, wasn't such and such absolutely fantastic, and they absolutely nailed that point or that other point. On the law, I think Lord Neuberger mentioned that some of us thought the sentence was a little on the low side, and the reason for that, and there's no reason you should have known that, is because the case of Turner you referred to has been subsequently doubted by the Court of Appeal. They said that was all well and good for 1975, but now you might be looking more in the ballpark of about 30 years for this kind of serious professional planned robbery. So bear that in mind before you start breaking into shops. But other than that...
You see, he's a tougher guy than I am.
Really good job both on the law and on advocacy style for everyone. Congratulations to all of you.
Absolutely. Is there anything anybody would like to say or ask? Not just the four advocates, but anybody in the, as it were, in the audience who, anything they'd like to ask. It needn't be about this, but anything you'd like to say or know. It's not really fair to ask you because you weren't expecting me to ask you that, but if there's anything you want to know or say, please don't be embarrassed about asking. As I always say, there's no such thing as an inappropriate question. There's only an inappropriate answer. And I hope neither Hugh nor I will give those. Anything anybody'd like to say? Good. Oh, yes, please. Good for you.
What's the most difficult case that you've dealt with, in your opinion?
That's a very good question. I think that probably as a judge, I've got one or two answers. When I was, there are three levels of sort of senior judge. There's a trial judge, there's a Court of Appeal judge, and there's a House of Lords judge, or now a Supreme Court judge. In the High Court, as a trial judge doing trials, my practice as a lawyer had been very much in land law. And because I have a science degree years and years ago, I was asked to do patent cases which involve science. And I had a case involving a drug that had been made with DNA, effectively, by massaging DNA. And I had to decide, with lots of technical evidence, whether the patent was a valid patent. It involved law I knew nothing about, science which I knew nothing about, and it lasted for 30 days. And I think it was, for me, the most difficult judgment I had to write, because there was so much to understand that I didn't know anything about. In the Court of Appeal, the most difficult case I had to decide was probably for slightly different reasons. It involved the issue of whether or not evidence obtained by torture could be produced in court. The UK government wanted to produce evidence which might have been obtained by torture, not, I hasten to add, by the government, but by a foreign government. But the evidence had been obtained by torture. And it wasn't my area of law at all at the time. And I had two colleagues who thought it could be used in court. And I found it very difficult to decide whether I should strike out on my own or not. And in the end, I did. Because I was finding it difficult, my judgment explaining why I didn't think you could obtain this evidence was far too long, but at least it was there. And I found that very difficult. In the end, it was good news for me, because the case came to this court and they agreed with me. So it's a sort of, one's very good as a judge at remembering cases where you've been held to be right, and very good at forgetting the ones where you've been held to be wrong. I think the most difficult case in this court has probably been one involving assisted suicide. As you may know, suicide used to be a crime. So if you were, in one rather extraordinary case in 1945, somebody was convicted of trying to commit suicide and assisting somebody else to commit suicide, and was condemned to death for trying to commit suicide, which is a slightly odd situation. I think it was later reprieved. But anyway, in 1961, Parliament decided that committing suicide would no longer be a crime, or attempting to commit suicide. But if you assisted other people to commit suicide, even for the best and most loving of motives, it was a serious offence that could get you put in prison for 14 years. Now, if you go on 55, 60, 50 years on, lots of people think that's wrong. And indeed, the Director of Public Prosecutions often doesn't prosecute people who take relatives for loving reasons to Switzerland to help them where they can kill themselves lawfully. And yet that would be an offence in this country to help somebody go. And there was an argument by a man who had tragically had a stroke, and he couldn't move, couldn't talk. The only part of his body he could move was one eyelid. So he could blink one eyelid, and he could communicate with his eyelid, like sort of Morse code, if you like. And he made it clear that he was in pain, he was miserable, he wanted to die, and he had no prospect of dying. He could have lived for another 30, 40 years, and he wanted somebody to help him die. He was miserable. And nobody would help him die, because for a doctor or nurse or anyone else who was looking after him, that would have been an offence. They would have been prosecuted. And we were asked to say that this law was an interference with his rights. And there were 9 of us who heard it, and we had rather different views, but the general message was that we thought the law was not in a satisfactory state and Parliament should try and sort it out. But it involves some quite complicated law involving human rights, involving moral issues and so on. And I think that was a very difficult one. So those were probably, it's a very long answer to a short question, but those are my 3 most difficult cases, I think.